Just waiting for the recording to start. Okay. Okay, welcome. Thank you for making time to join me on this Saturday morning. It won't be long. I won't take long. Just want to quickly run through some aspects of the test, some pointers to help you with your preparation. I'm going to share my screen. Okay, thumbs up if you can see the screen. It's just a blank page at this stage. Can you see that? Thumbs up, somebody, if you could see the I've successfully. Thank you. Okay, so normal procedure. If you have any questions, feel free to interrupt. So let's start with the layout of the test. Layout is pretty much standard. You should be expecting this. If you've been in my class, this is now your second semester in my class, should have realized that my tests pretty much look the same. They have a standard. I have a standard layout that I tend to follow. So obviously we're starting with multiple choice. Ten questions, 2 each, gives us 20 marks. I have reopened the practices on e-learning, not to say anything about multiple choice. Free and go and do that quiz as many times as you like. It will be open until just before your test. Then question 2, as always, short knowledge-based questions. Total of 10. Is a discussion question for 5 marks. Question 4 is a case study based on, as I warned you, Unit 8 for 15 marks. It's not a single question for 15 marks. I give you a case study and a number of questions based on that case study, divided, so it's divided into questions. So your short knowledge-based questions, you know by now. Please watch your mark allocation. It's a 2-mark question. Then I don't want half a page. If you find yourself writing half a page for a single 2-mark question, you're writing nonsense. Question 3 is a theoretical question. It's a discussion question, literally about law. I give you a scenario and you need to discuss theory behind it. It is not an application question. It is not a case study. You don't have to come to a conclusion. It's about the theoretical legal background. A quote, not a case study that I give you. It's a quote that I gave you that comes from a court case. Not a court case that we discussed in class. So don't stress about it. You don't need the background to the court case. It's about the principle that you must discuss. And the case study, Unit 8. Remember, I give you the handout with the selected extracts from the Companies Act. No marks are awarded for copying directly from the extract. It's all about application. Okay, let's see. How am I going to do this? Quickly going to run through each separate unit that's covered in the scope of the test. Units 1 and 2 were basically about the legal name of a company. The fact that the company is a juridic person. Remember, make sure that you understand the concept of a juristic person. What is a juristic person? What are the consequences of an entity being a juristic person, having legal personality? And then also already in Unit 2, we came across this distinctive feature. Distinctive feature of company, namely your separation between ownership and control. Your board of directors versus your shareholders. This has been in all the units so far. This has been like a golden thread that has been running through our lectures. It is essential to a company. Not always that apparent when you have a public company, a private company, but specific when it comes to your public companies. It is essential to the concept of a company. It is essential to good corporate governance that these two organs are separate and that the one cannot interfere in the right duties and responsibilities of the other one. Unit 3, let me just quickly remind me what Unit 3 was. Unit 3. your different types of companies, companies with a shareholding, companies with shareholding, public companies, private companies, non-profits. You need to know the difference between these types of companies. You need to also be able to identify a company. I give you the name of a company in a case study. You need to immediately make a mental note of what type of company am I referring to. I will never tell you in a case study, ABC Limited, which is a company, that which is a public company, you must add yourself. Certain provisions of the Companies Act that do not apply to private companies. So in certain instances, your final answer that you give will differ depending on the type of company. So always aware of what type of company we are dealing with. Unit 4, the constitution of a company, your memorandum of association, and your articles of association. Important takeaway from Unit 4 is the legal relationships that flow from the Constitution. The Constitution is a contract, the contract between the company and its members. It is a contract between the members, natural relationship, the members. But only shareholders derive any rights from the Constitution. Shareholders only derive rights from the Constitution in their capacity as shareholders, not in their capacity as directors or any other position in the company. It is only about membership, rights of members. How does this contract come into existence? Remember, I pointed out to you that it is only once. It is only signed upon incorporation when the company is registered. It is signed for the first time, but the Companies Act in Section 7, I think it is, states that the Constitution is deemed to have been signed. It is taken in law as the shareholders signed. It is deemed to have been signed. They don't sign it personally. So never tell me that Johnny, who became a shareholder 5 years after the company was registered, never tell me he signed the contract or he signed the Constitution. No, he didn't. When you become a shareholder, member of a company, you don't go to BIPA and go and sign the Constitution. It is deemed to have been signed. But because it is deemed to have been signed, introduction to law for accountants, what does signature mean? It's deemed to have been signed, so shareholders are deemed to have knowledge. So whether they actually read it or not, that knowledge is imputed to them. It's a public document. They can always go and ask for a copy at the Registrar of Companies, at BIPA, and acquaint themselves. They are deemed to have knowledge. That knowledge is imputed to them. They're deemed to have knowledge and are bound by the contract. Let me just sort my formatting out. Unit 5. Unit 5 was about capital of a company. The different types of shares, different classes of shares. Remember, types of shares. Types of shares, we only get two types of shares. Shares with a par value and shares without a par value. When it comes to Unit 8, the application of voting rights, etc., etc., I will always work with par value shares. Get two different types of shares. But then we get different classes of shares. So don't confuse types of shares with classes of shares. Types of shares, par value, non-par value. Classes of shares, ordinary, preference, deferred, etc., etc. Have a very good look at preference shares. It's quite a lot of information about preference shares there. Make sure you understand that. Preference shares, what mean when we say preference shares are cumulative? Preference shares have a right to receive a dividend annually, but dividends are only paid if they have been declared by the board of directors. Shareholders can never force directors to declare a dividend. That remains a management prerogative. If, however, in a particular financial year, the board of directors does not declare a dividend, the preference shareholders' right to receive that dividend doesn't pay. These unpaid, undeclared, and unpaid dividends accumulate. They add, and when if the directors feel the company is financially stable, then arrears dividends must be paid first. So in 2024, no dividends were declared. 2023, no dividends were declared. 2024, no dividends were declared. 2025 dividends are declared. The outstanding amounts due to the shareholders dating back to 2023 will be paid first. And then those dating back to 2024, etc., they are fully paid up to date. So they continue, they build up, they accumulate. They have the right to subsequently receive payment when declared, but they do not have a right to claim the dividends if they have not been declared. They cannot force directors to declare dividend. Important that you understand that. Concept of cumulativeness in different shares. Also, the redemption of preference shares. Certain preference shares are issued as being redeemable. When they will be redeemed and at what premium, at what profit, will be stated in the conditions of issue. So when you acquire preference shares, you know that you acquire them and they will be redeemed at a certain time. Doesn't give you the right to want to give them back or sell them back or whatever to the company before that time. Preference shares are redeemed at a fixed time, after a fixed period of time, at a fixed premium. Money used for the redemption of preference shares only come from one of two or sources, either from issue of a new issue of new shares. So if they want to redeem shares, they have to issue shares to Johnny and use the money Johnny paid Sally, or from profits available, divisible profits, profits available for dividends. So redeeming preference shares does not affect the share capital of the company indicated in its balance sheet. That will remain the same. Make sure you understand the concept of class rights. What are class rights? Class rights are rights that are unique every class of shares. That's what distinguishes one class from another. The variation of class rights. Variation of class rights. Class can be changed. In order for class rights to be changed, the majority of the shareholders of that particular class must consent to the change. If I can go back here to preference shares, also concept of when may they vote. When do preference shares have voting rights? They have voting rights if their dividends are in arrears, or if the resolution directly affects their class rights, if it's going to lead to a variation of their class rights. When are class rights varied? When are they changed? If there's a change in the substance of the rights, if the decision to be taken could potentially affect the value, the market value of these shares, it's not a variation of class rights. You do not, the value, the market value of your share is not right. That is why investing in shares is considered a high risk value, because you never know whether they're going to increase in value or maybe lose their value. You have no right as a shareholder that you must be able to sell your share for a certain amount of money. As a shareholder, you have the right to be able to vote at a meeting, that type of thing. Those are enforceable rights. And if those rights stand to be affected by this decision, so the substance of the rights, it is considered a variation of class rights. It's just affecting value. There is no variation of class rights. Is this important that you understand this? Because it affects the voting rights. which means when we get to unit, it is going to be important. That is, if I can just help myself for a moment, something that you must, by in your study of company law, started to pick up, started to realize, is that all these units are linked to each other. When we did Introduction to Law for Accountants, there were separate units, and every question I would be about something in a particular unit, but I didn't scramble them up. Company law, however, doesn't work that way. All of this information you've got so far is in print. So in test 2, for example, test 2 is, I don't have it in front of me, but let's say from unit 9, unit 12 or 13. But I cannot assess unit 12 and 13 without also having to apply knowledge which you gained in unit 1 to 8. Example of this whole issue of when may preferred shares vote? When is there a variation of class rights becomes relevant in application of unit 8. So I cannot assess unit 8 without also assessing your knowledge of unit 5. You need to know when are class rights varied. What is a variation of class rights? And so just be careful here. The distinction between becoming a shareholder, become a shareholder of the company. How do you obtain shares? Either directly from the company, so you apply to the company allots shares to you, you pay for them, the shares are issued to you. You pay the company. Or by acquiring, so these are new shares, or by acquiring existing shares from an existing shareholder. One shareholder sells their shares to another shareholder. These are existing shares, and payment is paid to the shareholder, not to the company. Distinguish this, don't confuse the two. Becoming a shareholder, becoming a member. How do you become a member of a company? One of two ways. Either, I mentioned it here, by signing upon registration of company, signing the memorandum of association. Those for the first members of a company become members by physically signed the memorandum of association. Subsequent to that, members don't sign the memorandum of association. How do they become a shareholder if they're a member? How do they become a member if they don't actually sign the constitution? They become a member by agreeing to become a member and having their name entered in the register, the list of members. In a company with a shareholding, becoming a shareholder and becoming a member goes hand in hand. The moment you acquire shares, you agree to become a member. You cannot be a member of a company with a shareholding without also being a shareholder. Once you have agreed to become a shareholder, once you've acquired shares, that immediately have agreed to become a member and have your name entered in the register of members. You cannot have the one without the other. That's Unit 5. Unit 6. We didn't do this semester. Left that one out. Unit 7. Short unit, but once again, important. It takes us back to this thing. Gives more information about that, about the organs of a company. The organs of a company are your board of directors on the one hand and your shareholders, members in general meeting on the other hand. Who is the boss of them? Neither one of them. Particular roles, responsibilities are defined in the constitution of the company, in the articles. And both the organs of the company are bound to the articles. Actually, that one must rather be there to just have the sequence right, that there's a separation between ownership of control. Articles define the rights and responsibilities, and the one organ cannot dictate to the other organ what they should or should not do. This is something, and this whole concept, the separation between ownership and control, is crux foundation of corporate governance. That the board of directors be independent from interference by the shareholders. This is something which very often, if you read the news, there's literally in the news at the moment, I read it yesterday, there appears to be some controversy again in a state-owned enterprise. I'm not, if you want to go and read it, find yesterday's newspaper. I'm going to name the state-owned enterprise. This is something which there's an ongoing tendency in Namibia, in our state-owned enterprises, that the shareholders, or in where by shareholders, the shareholder of a state-owned enterprise is the government, represented by the relevant minister. And it happens time and time again. There are so many examples where a minister, a government minister, the particular portfolio minister, interferes decisions of the board by them, trying to say to them what to do. The board is with appointing a chief executive officer. Next moment, the minister calls them and says, no, you can't appoint that chief executive officer. Cancel appointment, cancel the recruitment. I want you to appoint Johnny. From a corporate governance point of view, that is very wrong. shareholders must not interfere with decisions that fall within the realm of what are the duties of the board. So short unit there, important unit, and also not only important theoretically, but as I just explained, quite relevant to things that actually happen in Namibia. People read newspapers, then you'll start, company law becomes very interesting if you start relating it to things that are actually real. And then unit 8. Shareholder meetings. I have already done a whole revision class on unit 8 together with doing a practical exercise with you, showing you how to answer these questions. Remember, always show your calculations. You get marks for your calculations. Remember also that the use of a calculator is permitted. So I'm not going to elaborate on Unit 8. I'm not going to do Unit 8 again. You can go back and listen to that recording. It has been up. So that's your test. Any questions? Is it all clear? I've given you some pointers what concentrate when you start your preparation. Monday is institutional holiday, but I believe many of you, if not the most of you, majority of you, are employed, so you might not have the privilege of having Monday off. Sorry about that. Not Monday off. Tuesday's a holiday or your public holiday. If you're traveling anywhere, stay safe. Thursday, we will not class. You Thursday evening to prepare, and I will see you then on Thursday, on Friday evening. Those of you that are writing in winter, the test will also be to all the regional centers for students that wish there. Okay. Thank you very much. Thank you for joining in. Bye.